Due process requires only that in order to subject a defendant to a judgment in personam, if he be not present within the territory of the forum, he have certain minimum contacts with it, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. The United States Supreme Court reaffirmed the minimum contacts maintained. The concept of minimum contacts, in turn, can be seen to perform two related but distinguishable functions. It protects the defendant against the burden of litigating in a distant or inconvenient forum, and it acts to ensure that the states, through their courts, do not reach out beyond the limits imposed on them by their status of co-equal sovereigns in a federal system. Before a court can exercise in personam jurisdiction, it must be convinced that the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hailed into court. The inability of plaintiff to recover an amount adequate to give the court jurisdiction does not show his bad faith or oust the jurisdiction, nor does the fact that the complaint discloses the existence of a valid defense to the claim. But if, from the face of the pleadings, it is apparent to a legal certainty that the plaintiff cannot recover the amount claimed, or if from the proofs the court is satisfied to a like certainty that the plaintiff never was entitled to recover that amount and that his claim was therefore colorable for the purpose of conferring jurisdiction, the suit will be dismissed. Events occurring subsequent to the institution of the suit, which reduce the amount below the statutory limit, do not oust jurisdiction. Paul Mercury Indemnity Company versus Red Cab Company, 303 U.S. 283, 288 to 289, 58 Supreme Court 586. As the Third Circuit stated in Nelson, to find plaintiff's claim lacking in good faith, the court's claim backing in good faith, the court must be able to conclude from the record before him that the plaintiff cannot recover a sum by way of damages above the $10,000 jurisdictional floor. 451 F. 2nd at 293. Plaintiffs allege in counts 1 and 3 a breach of contract. In court, they allege that Cohen fraudulently induced plaintiffs to send defendant the money order when he knew that Simone would not perform at the Civic Center, and that as a result of this representation, plaintiffs suffered damages exceeding $10,000. In count 4, plaintiffs claim damages for intentional infliction of emotional distress exceeding $10,000. Whether or not these allegations are true, the amount in controversy has been sufficiently alleged to exceed $10,000, exclusive of interests and costs. Therefore, this court holds that it does have jurisdiction by reason of diversity of citizenship and amount. Defendant has also failed to persuade the court that the complaint has fatal defects simply because plaintiffs improperly designated count 3 trespass rather than a subset. Plaintiffs need not have labeled these counts at all. In Conley versus Gibson, 355 U.S. 41, 47, 48, 78 Supreme Court 99, 103, all the rules require is a short and plain statement of the claim that will give the defendant fair notice of what the plaintiff's claim is and the ground upon which it rests. The illustrative forms appended to the rules plainly demonstrate this. Such simplified notice pleading is made possible by the liberal opportunity for discovery and the other pretrial procedures established by the rules to disclose more precisely the basis of both claim and defense, and to define more narrowly the disputed facts and issues. Following the simple guide of Rule 8F, that all pleadings shall be so construed as to do substantial justice, we have no doubt that prisoner's complaint adequately set forth a claim and gave respondents fair notice of its basis.